So thank you, Agata, for the great introduction. We really appreciate that. As Agata said, my name is Emily Tofty-Nastavo. I'm the Executive Director here at the Rocky Mountain Victim Law Center. A little bit about my background. Before I joined the Rocky Mountain Victim Law Center, I was a community-based advocate and working in previously both in sex assault organizations and also domestic violence organizations. So hopefully have a pretty good view of where you all are coming from, and as a non-attorney, would love to talk about the unauthorized practice of law, because I do work for a law firm and run a law firm, but I'm not an attorney, which is an interesting practice. So this is a conversation that we have really consistently among our staff, and feel like it's a little bit of a gray area, and feel like we can share some good information with you all today.
So my name is Ashley Ahrens. I'm the Client Services Director here at the Rocky Mountain Victim Law Center. I've been in this role for about two and a half years. I also come from a community-based background, so I think this has been the first time that I've worked in an organization where UPL was such an important part of the conversation. So I think just in my experience, having learned what this is for the first time, I hope I can bring that sort of side of things to this conversation as well.
Excellent. And we're going to try and make this very interactive so it's useful for you all. So we hope that you all bring some examples of things you face or questions you have. So as Agata said, if you have things that are coming up or questions as we're going through, please type them into the chat box. We will be monitoring that pretty consistently as we go through the webinar. But first we're going to start out with a poll, and we want to know who you all are. So if you could, I think you'll see here in a second, you should be able to see the poll. We're asking who's in the audience. If you could click which one describes you the best, that will help us understand. And if you are selecting other, we see a few people who are logging in as that. If you could write that in the what other means to you in the question box, that would be helpful so that we understand and can talk directly to that. Yeah, under questions. That's it. Yeah. Give us 1 second. We see some answers rolling in. We'll close it here in a second. We see one of the others is a sex offender coordinator. Welcome. Thank you for being here. All right. It looks like the majority of folks who are on with us today are, hello, Andy Martin. We see you chiming in as well. It's good to see you here. And we have, most of y'all are community-based advocates, so welcome. Thank you. We've got a few people who are prosecutor, other attorney, a couple of folks who are within systems based, so I'm guessing sheriff's office, law enforcement, maybe a district attorney's office as a victim advocate. And yep, Ashley's going to close the poll and we'll jump in. So thank you all for being here. It's good to know who's in our audience. And thank you to those who have chimed in via the question box, because that is helpful to know that that's working on our end. Perfect.
So we have another poll. You've gotten your poll, the first one out of the way, which is always the most stressful. So now we're ready to ask you another question. So we're wondering whether or not you have said this or something similar to someone that you worked with, a client. So if you go ahead and answer, that would be fantastic. It's just starting to get some of our first answers, seeing about 20% of folks having voted so far. Please feel free to chime in. This is an important sort of setup for the rest of the conversation. So, and also sort of our way of just getting people engaged here at the beginning so that we can have a conversation based on people's own experiences around saying to someone, I can't give you legal advice, but, and what that might look like in a way that's both not the unauthorized practice of law, but then potentially is.
And also, if you're writing in, there's a few people who are writing and saying, I've said something similar. Type what you've maybe said or what's part of your regular speech to those you're providing services to that is similar to, I can't give you legal advice, but let us know what that looks like for you.
We're seeing about 60% of people, so we're going to give it a couple more seconds just so that the last few people can chime in. It looks like someone was asking what the question was. The question is, how many of you who are participating, who are here on the webinar, have said something similar or have exactly said, I can't give you legal advice, but,
and then fill in the blank.
So we're about 75% of people, so I'm going to go ahead and close the poll. And I'll share with you those answers. So it looks like 61% of people have said yes, they've said something like that. Another 30% or so have said they've said something similar, and 11% of you said no, I've never said anything like this remotely ever in the history of all the time that I've been working with people as a victim advocate or other. Excellent. Let me go ahead and hide those results.
So what we're going to start off with is the definition of what the unauthorized practice of law is, and we'll probably refer to it frequently as UPL. So if we're using that acronym, just know that we're using the shorthand version of unauthorized practice of law, which is a term of art. So generally, how we define, and I'm looking at slides over off to my left, so excuse me if I keep ducking out. The definition is that the unauthorized practice of law is acting as a representative in the capacity of protecting, enforcing, defending the legal rights and duties of another in counseling, advising, and assisting another in connecting with these rights and duties. So in some ways, I think coming from a community-based background, that sounds a lot like what general advocates do, is assist someone, help them understand their rights, ensure that their rights are being met. And this is where I think we start to get into the gray area, and we hear community-based advocates going, what's really the difference between providing legal advice and the unauthorized practice of law versus giving someone the support they need as they navigate some really complex legal issues as victims of violent crime or survivors of sex assault, domestic violence, etc.
Especially in the less obvious ways, right? I don't, as an advocate, go into court and argue things or practice law in that way, but we want to make sure we get to the sort of the gray area where we're not in court, but what does it mean to still act as someone's representative or protect and enforce and defend their legal rights in a way that can sometimes seem a little ambiguous when we think about how we usually and typically define ourselves as advocates.
So the Supreme Court in Colorado makes clear that providing legal advice to another person in any capacity, if you're not an attorney and you're not a barred attorney, which is important, that it constitutes a practice of law, as does the selection and drafting of legal documents for use by another person. And we're going to talk a little bit more about the selecting and drafting of legal documents, because I think that's also a tricky area, especially when it comes to the things that we see community-based advocates more often doing, like protection orders. And that there are forms around that. And generally, a non-attorney's, a non-lawyer's exercise of judicial discretion on behalf of another legal interest is prohibited because of the potential harm to the public. So basically, what that says is, as community-based advocates or non-attorneys, that we don't know all the ins and outs, and that's okay, of legal practice and what ethical responsibilities are. And we, as non-attorneys, never want to provide someone guidance or advice that would lead them down the wrong path, and that we can really leave that up to attorneys, because there's a reason why attorneys go to school for so long and why they practice for so long and have to pass the bar, etc. And while many of us have been doing this work for a very long time, there's still big nuances that we can't presume to know because we don't have that education and or training. But that doesn't mean that there's nothing you can do when it comes to legal stuff as pertains to a victim and what's going on with them. In fact, there's lots of things. So generally speaking, a non-attorney can't provide legal advice to another person, cannot select legal documents on behalf of another person, cannot draft legal documents for someone else, interpret the laws that might apply to someone else's situation, or represent a person in any legal transaction or matter, or prepare another person for trial or a court hearing. You want to add anything to that? Nope. Yeah. And there are, and we're going to get into examples to make this really practical. So we're going to kind of zip through some of the slides, and then we're going to go back and unpack what this all means to you all in your practice and work in working with survivors and victims. So there are liabilities and consequences. If you or someone within your organization is found to be practicing law without a law license, there are liabilities and consequences that kind of run a spectrum of what could happen, which is partially why this is so important. One of the consequences can be that you can be written up and that you will no longer engage in the unauthorized practice of law, which is kind of the lowest bar to pass in that. There could be injunctive proceedings, contempt proceedings, and other sanctions, like you might lose a professional license for sanctions. So if you're a licensed counselor or a licensed social worker, that could definitely come up in your licensing, all the way up to criminal prosecution. And I think that is really important to know, that it does run this very broad spectrum. And as advocates, we walk sometimes a very fine line between giving really good information, support, and advocacy to victims while not practicing law.
So some of the roles, I think, as an advocate is to, and how this sometimes can be challenging, I think, for folks, is that as victim and survivor advocates, we provide information on victimizations and on a victim's legal rights. And all that a lot of times falls into that legal arena, right? We're talking about someone's legal rights. We may not necessarily be participating in the unauthorized practice of law, but we're going to be talking about things that fall into the legal realm. So I think the other piece, providing information obviously on the criminal justice process and what that looks like.
Shoot, sorry, I'm pushing buttons and it's driving Ashley crazy. Pardon me, everyone.
We provide emotional support to victims, so that's an area where usually we don't feel as concerned about UPL because it is something that falls so squarely into the realm of social work or advocacy. Certainly helping victims with safety planning and victim compensation applications, as well as submitting comments to courts and parole boards, intervening on behalf of victims in a number of different systems, whether that's the criminal justice system or into other systems in which the victim is involved, and then providing referrals for other services for victims. So I really want to pull out of that some of the things that we're going to go more in depth on here shortly. Things like the victim compensation applications, helping submit comments to courts and parole boards, and then intervening on behalf of victims. That's usually an area where we just want to make sure that we go into enough depth. I think those are areas where folks often get concerned that they're providing the unauthorized practice of law. Same thing with information on a victim's legal rights and really walking with someone through their experience in their case.
And so part of why I was pulling up, I wanted to make sure that we were seeing questions as they come in, and thank you all for who are chiming in with questions. And we see, you know, questions around, should we have a lawyer present when talking to a victim? We're going to get to all of that, and it's not necessary all the time for there to be a lawyer present when talking to a victim. So that's important to know, but we'll talk about why and when it might be helpful to have a lawyer present, and what kind of lawyer you might want to have present, because it's also very important to know that having a district attorney who is an attorney and a lawyer is very, very different than having a private attorney in the room as well. So what we're going to do right now is actually launch another poll question. I just need to find, Ashley's going to do it. Bear with us for 1 second.
I think I have to share the results from the last one, sorry. And then let's go ahead and watch this.
So this one is a little bit more of a nuanced question, and it's a little bit of a scenario. So when you're perhaps helping a survivor or victim fill out a protection order, they have questions for you about a protection order. This survivor in our scenario has a lot of questions about how they should phrase certain things, what they should include, what they shouldn't include, and we're curious what you do. So the options are, you write down everything that that victim survivor is trying to convey to you. You tell her, you tell her what to include based off of what you think is relevant for her and in order to get the protection order. You tell the survivor that you can only provide information and options for how to proceed. D, you say you cannot answer legal questions and only an attorney can, and usher her out the door. Or none of these other. And if you're selecting none or other, please chime in into the questions box and let us know what your answer is. Excellent. And we see a few things coming in. About 70% of you have weighed in. Someone weighed in and said, I have the person write down on a separate piece of paper what happened to them and go over it with them to help narrow it down and rewrite it on the ex parte form? Okay, looks like answers are slowing down. Let's see, I sit down with the victim and answer any questions I can or imply in the past victims have put. I'm not allowed to help fill out VPOs with the law firm I'm with, and someone else in the community does that for them. Okay, so you might refer to some organization that actually specifically does protection orders. Tell survivors to write down what happened, just like they have told me, and to write it down like you are all talking to me. Okay, perfect. So we're going to close the poll now and share answers with you all. And 15% of you said tell her what to include based off of what is relevant for her. 48% provide only information and options for how to proceed. 11% say you cannot answer legal questions and usher her out the door. And about 26% of you said you would do something a little bit more nuanced than what our options allow for you to do. So we're going to go through these one by one. I'm really happy to see that nobody answered A, because that is very squarely the unauthorized practice of law. B, there were a few folks who answered tell her what to include based off of what is relevant for her. You want to respond to that?
Sure. So I think part of what can be a challenge there is that when we're telling someone what we think is relevant, that is the unauthorized practice of law. We as non-attorneys, we can't determine what's relevant to someone's legal case, and it goes back to what we were talking about before, this concept that we wouldn't want to speak to something that we don't have a full understanding or knowledge of, which we certainly cannot have without having gone to law school. Because there are significant legal ramifications to filling out this form in a certain way, or adding or not adding certain information.
So as advocates, some of what you can do, and the majority of you responded that you would lay out all the different options and only provide information which is actually the correct, well, one of the correct answers. The other may have some correct answers, may not. But when we talk about walking that line, essentially what you can do as non-attorneys is you can provide information. So essentially, if you can Google it and find it on the internet, it is fair game to share with a victim survivor as a non-attorney. If you are taking that information that you find on the internet or have learned in a webinar like this, or maybe you have come to a different presentation that the Rocky Mountain Victim Law Center has come to, and you are taking that information and saying, here's how this applies to your case, that is the unauthorized practice of law and something only attorneys can do. So one of the questions that comes up for us really frequently is, well, how do I do that without the victim survivor feeling really frustrated? And this is where we talk about advanced advocacy and how you can take it to the next level so that there is a nuanced gray area between saying, hey, you know, I'm not an attorney, I can't provide you legal advice, you're going to have to go find an attorney for that, and maybe you give them some names and people they can call, which is not always the right answer. You can say more than that without practicing the unauthorized practice of law. There's also things you can do without just referring them, if they have a criminal case, for example, back to the district attorney, which is not always and usually not the right answer because district attorneys cannot provide legal advice either. And there may be certain things that could impact the criminal case where maybe the victim survivor has a civil legal question, which I think some of you may have attended our first webinar that's about the differences between the civil and criminal system, and could actually distract from their criminal case. So it's not always a great idea, if the issue itself doesn't relate to the criminal case, to be referring it back to the district attorney. So the correct answer that we normally say is provide a lot of information and go through it. So when I think of advocacy and all my years in advocacy, there is a way to say I can't provide you legal advice, but here's generally what happens in these situations, and here are the choices that you could make around this. And then you go into more of those social work skills about what feels right for your situation. You know this better than I do. I can't presume to know what's right for you, and I can't tell you what's right for you. And that type of advocacy and support requires some nuanced skills, as you all know, and it takes a lot of time. But that is what we're always recommending, is give that information freely. You can talk about what you have seen the judge do and has not done before if you're really familiar with that court system. But you can't say, but here's what you should include because that's why. This is what the judge normally advises.
And I think part of that too is, there does come a line in the sand where someone who really does want that specific information around what should I put in here, I just don't know what to do, and the information that you as an advocate are giving me is making this more complicated. That's when we really have to resource within the community and find out who's a good attorney to talk about these issues, who is able to advise someone even if there is it's only a small question. And I think this goes to one of the questions that popped up in the question box, which says that this person wrote that we work with people who have intellectual and developmental disabilities and often cannot complete such forms by themselves. How are these circumstances accounted for? They are not accounted for by allowing advocates to do that for them. That is just not something that we can do, and it's absolutely the unauthorized practice of law. That being said, there are a number of resources in the communities where attorneys are on staff and work with folks really closely to ensure that they can get the appropriate legal advice in a way that they can understand, and that allows them to be empowered in the decisions that they make. And often it's because there is a partnership between attorneys and social workers who maybe have a better understanding of how to communicate, how to share information, or have a background in working with folks who have intellectual or developmental disabilities. So that would be sort of my answer to that question, is make sure that we have strong collaborations in the community to meet the needs of victims when they come in. If they do need that more intense legal advice around how to fill out forms, or particularly what they should do in terms of behaviors that may impact some sort of legal aspect of a case they have.
We also know, so Rocky Mountain Victim Law Center is a statewide organization, and we know that building those partners can be particularly challenging in rural areas where there may be very few resources or folks who specialize in these areas of law to be able to provide that support to victims. One of our projects that we're working on is providing trainings to attorneys in areas across the state. We're in partnership with the Department of Criminal Justice Office for Victims Programs to be able to train and recruit attorneys to be able to have capacity to provide some of those legal services in the most vulnerable and sparse areas. So I think in the next year or two, you may, if you're not in a metro area where there might be attorneys, you may see some enhancement with that. But we also recognize that this is a gap, and for some of you, it might not be possible to reach out to the nearest attorney. What I can say from having worked in rural communities as a community-based advocate is keep reaching out and keep trying to build those relationships. That even if you get a no at first, I think you can win hearts over by really explaining and what victims go through and why they need help. But I also don't want to sound short-sighted that we understand that there is a particular barrier there, especially for rural communities where access to some of these resources isn't as easy. One of the other things I'll say is there are a few statewide organizations. Colorado Legal Services exists in most communities that is accessible. Also, Rocky Mountain Victim Law Center is a statewide organization, so any of you all can call us for either resources. We might know someone in your community through our particular networks who we might be able to help bridge a gap, or we might be able to give you some guidance on how to proceed forward. So that's kind of the long answer to that particular question. We have another question about saying a district attorney can't give legal advice, which often catches people off guard, and it's true. They cannot provide legal advice. District attorneys they represent the state of Colorado. They do not represent the victim, and they cannot provide advice or guidance to a victim about what choices they should make, because it's not the victim who's bringing that case in a criminal process. It's the district attorneys who are bringing the case on behalf of the victims, which is why we focus so heavily as the Rocky Mountain Victim Law Center on what are the criminal legal rights that a victim has during that process, so they're not left out and their voice is heard, and that they can have a meaningful experience as they participate in the criminal justice process.
So we're going to keep moving right along. Excellent. Somehow, pop-ups off the screen. There we go.
So we've talked about some of this, about how to be an effective advocate within the criminal justice system, and some of this actually applies to the civil justice system as well. And I'll let Ashley kind of take the lead on this one.
Yeah. So we want to make sure that when we're talking about advocacy, we become more than just obviously a friendly face in a complicated system. we can be, this is what Emily was talking about a moment ago, this idea of advanced advocacy, ways to be effective in the criminal justice system beyond just being emotional support. So I think a big part of what that looks like is starting on the front end of building relationships with the district attorney's office, getting a really good understanding of who's there, what are their roles. For our office, the big thing we talk about is who has confidentiality and who doesn't. Going back to the question we just got, who is able to provide insight and information to a victim about their case, and wanting to have that understanding so that later we can call on those partnerships, call on those relationships when there are issues. It's harder to ask for something if you don't have a connection to things before. That's why RMBLC works really hard to build collaboration so that when we come into a case to help prevent, you know, for example, a victim's rights issue or complaint from being filed, or to help reduce the likelihood for that happening, we have relationships that we can reference, that we can build upon to work in collaboration as opposed to conflict all the time. I think another big piece of that is also building collaboration and connection with who's in the community that you might be able to get help from. You know, obviously we list ourselves, but also the other program in our office, the Colorado Link program, the Legal Information Network of Colorado, which currently is Denver specific, but wanting to know who in your community could be able to give legal advice, who could we seek out to get more information about how a victim should handle something. This part of advocacy is a lot of community organizing, which is exciting for a lot of folks when you're in grad school and you're like, yeah, I really am into community organizing, but once we get into the actual day-to-day work, we sometimes forget that because there's always such a huge influx of clients. There's always more that we can be doing on the cases we've already been assigned, but that collaborative role is really not something that we can take for granted or not put time into because it benefits our clients so significantly in ensuring that they're getting the services that they need in a holistic and full way. Obviously, number 4, we want to always provide our clients and survivors with correct information so that they can anticipate what's coming next. This is a big area where we don't need to be doing the unauthorized practice of law because we have correct information. We can tell people that information. We don't need to analyze it for them or apply it specifically to their case. That's not our role. But we hurt everyone in the process if we don't have appropriate information. This means understanding the sort of the pathway of a case, sort of the general anticipated next steps that someone could see happening, and the anticipated hiccups that often happen. I think a lot of times we hear from folks, well, I never knew that there could be a continuance. I never understood how long this was going to take. You know, those roadblocks and those obstacles are often what frustrate victims so much and allow for the disengagement process to begin sort of snowballing by not knowing what to expect, what to anticipate. And so community-based folks can really, as we get a better understanding of the criminal justice system, get more involved with how things usually go, we're able to help reduce the burden on systems-based folks to provide all that information. We're able to give it to a victim from all different sides, which also helps individuals who are victims of crime because the trauma that exists within the brain and the ability to retain and create new memories, it allows someone to hear it from so many different people that perhaps it will stick in a way that allows them to better anticipate what could happen next. And then last but not least, ensuring that the court knows if the victim wants to enforce their rights under the VRA and that the prosecutor is not going to be doing that for them. This is an important piece, and I always like to harken back to the idea that we want this to be victim-centered as well. So getting a good understanding of what are our victims' rights, which ones do they want to enforce or participate in, and then making sure they understand how that might look in the system as they go through a case. So just getting a really grounded and solid understanding by going to a VRA training, by getting someone who's done this type of work before to walk you through the process and what they typically see. And then sort of learning as you go as well, which is so common for social workers, walking through the system with someone, taking notes and being able to impart that information on others as you get further and further into your education or further and further into your career.
And I think another part of advanced advocacy and being a really good advocate is being really comfortable with saying, I'm not really sure of the answer for that, or I'm not sure how to help you through this, but then going out and finding the right resource to help you. And Rocky Mountain Victim Law Center, this is what we exist to do, to provide you that kind of technical assistance and support when you're running into tricky issues about, like, hey, it seems like no one's listening to this victim. what is their right, how can we help them through this, do they need an attorney, do they not need an attorney? Those are questions that our office can answer for you. And I also think that knowing when you don't know something is just an incredible strength. So I want to go back to asking questions when you don't understand. A few good resources that you'll see on your slide there under number 3 include coloradolink.org. So over the past few years, Rocky Mountain Victim Law Center, along with some Denver-based organizations, have been engaged in a project to evaluate what are the civil legal services and gaps in services for victims, specifically in the Denver area. So even those who aren't in the Denver area, I think there's some things that we learned that may or may not apply to you. But one of the things we learned is around that victims said when we did a needs assessment that they often got inaccurate information from community-based advocates. And one survivor in particular, we use this quote quite frequently, said, in the morning I wake up with my legal question that's related to my victimization, and I call the 3 to 4 service providers that I've been working with. Maybe that's their therapist, their community-based advocate, their system-based advocate, perhaps it's a housing specialist that they've been working with, and they ask that legal question and say, hey, what should I do with this? And whatever answer they heard most was the one they believed was correct. There was such a variance in the answers that they were getting about their legal needs that they figured that majority won, which is really startling to not only us, and I'm sure that resonates with some of you out there as well, that access to accurate information about what are basic terms, what do things mean, is really important. And so that's where the coloradolink.org website is something that RMVLC developed with our partners on this project, and it has some of those legal definitions readily accessible there that are accessible. They've been translated into an 8th to 10th grade reading level so that it is not in legal terms. I know, as me not being an attorney, I really appreciate that sometimes is, what does an acquittal mean? What is an arraignment? When they keep talking about continuances in the criminal case, what does that mean? And what is the legal definition of domestic violence versus what we as community-based advocates use as the definition of domestic violence, and how that may or may not impact maybe what law enforcement is doing about your case or the case of the victim that you're working with, etc. And so that is something that I would point you all to, and you can even give it out to victims. You don't have to be in the Denver area to use that website, but it is based on Colorado law, and it is based on information that we know that victims of crime typically have, and so would encourage you to use that. And also, if you need a direct line to someone, that's where you can call our office and just say, I have this thing going on, can you help me with it? The other thing that I think I wanted to point out is that, we'll get to that in a second. I'm going to look at the questions.
So the first one is asking, I've had advocates who work in protection order clinics say to victims that they should put info into the protection order application on why they want a PO and what they might be fearful of if they do not get one. Is that advice? So I would say that it's really a lot in the way that you say things. What might be the unauthorized practice of law is saying, you should definitely put this in here. This will help your case. You should do or not do this thing because I think that it will be helpful or not helpful. The way to potentially avoid that could be to say, I've seen in the past that people have included this. You might want to consider including it or think about whether or not you want to include this. It's really the should part, saying that I believe you should do this because it would benefit or harm you. That is the unauthorized practice of law. So really, when I'm sharing with people what I've seen in the past, it's usually more trends or anecdotal information. So I've seen this to be helpful for people in the past. You need to make your own decision about whether or not you think that's important. If you'd like more clarity about that, you'll need to talk to an attorney who has a better understanding, but here's what I've seen victims do before.
Yep. I think that's really good. And we talk often about if the word should is coming out of your mouth as a community-based advocate and a non-attorney, that's a word that you should strike from your vocabulary, and if you do that, likely you will be avoiding the unauthorized practice of law. So we often also kind of make the joke that you shouldn't should all over your clients, and so, or the people that you're serving, which is really important. So just like in some of our basic advocacy trainings, we often talk about how we don't ask victims or survivors why they did X, Y, or Z. We don't say, why were you at that party, or why were you drinking, or why didn't you leave? Those are really un-trauma-informed, not victim-centered questions, and they really don't matter, right? I think we mostly all agree with that. And just like you don't ask the question why of victims and why they did certain things or why they didn't do certain things, you shouldn't be saying you should do this or you shouldn't do that. Just like we don't say you should go report to law enforcement. We talk about the benefits of reporting to law enforcement and address their concerns, and we listen closely to what fears they have about what that process looks like, and we answer questions about what they might expect to experience, but we don't say you should or shouldn't do this.
Yeah, that's exactly right.
Another question that came up that said I started a few months ago was, what is some quick advice that you can give me on without giving giving advice without getting into legal trouble? So we would say we never give advice. So you never want to advise someone. And advice comes when you say, I would advise you to do this, or I think you should do this, or you want to include this. And it comes more to that nuanced language of, I can't really tell you what to do, but things that others have found helpful are including information about how this, why you might be fearful of this person when you're seeking a protection order, etc. The other piece that we see this come up a lot, quite frequently, is around releases of information. So often, if you have a survivor who's reporting to law enforcement, they might be asking for releases of information for a myriad of things. It might be for cell phone records, it might be for their mental health records, it could be for their school records. Those are the big ones we see.
Mm-hmm.
Are there any more?
Medical records.
Medical records.
Medical records just sounds frequently.
And as a community-based advocate, one of if you're not a barred attorney and providing legal representation to someone, what we should never be doing is saying, oh yeah, it's totally okay to find this, you should go ahead and do that. Or, yep, this is totally typical. So you can say, yep, this is totally typical for them to ask. But then you need to know the implications of what might happen with that information. That the victim survivor should be informed that if they say, sure, you can go, I'm going to sign a release of information for my cell phone records, that once that's in the hands of law enforcement, that's fair game, and the district attorney is going to have to turn that over to the defense attorney. And so in order for that victim survivor to make a really good decision about where they want their information and who they want that shared with, they should know that there is a possibility that their perpetrator might be able to see everything that's on their phone. And as we often talk about, is that there is things that are on your phone that you may think have been deleted that aren't. And so we want to make sure that when it comes to the privacy and those protections, it's not, the answer is not just, yep, they routinely ask for this, it should be okay. There's a way deeper and more nuanced answer that's really important. And if you don't know what could happen with that information, that's a perfect time to call in an expert who does know what might happen with that information, who can talk to that victim survivor before they're actually signing any sort of pieces of paper, and that information is out there.
And this really speaks to the portion of knowing what you don't know. I think that privacy and particularly how that relates to a criminal case is a really nuanced area. And I feel like that's one of the places where we can be really of a lot of assistance. I know if any of you folks who are listening now were at the privacy and safety training that Kelly Dixon, the legal director, and I did 2 weeks ago, that really was just brushing the surface. There's so much that comes up around privacy that it's very hard as an advocate to be able to fully share what those possible implications could be in a way that provides a victim with enough understanding so that they can make an empowered and a full choice that's truly informed. So definitely making sure you get connected with experts, whether that's our office or if you have someone else who's a privacy expert, really really talking with them and talking through those issues. I think additionally, you know, it's to go back to what Emily was saying, really there isn't anything within how we do or should be doing advocacy work that allows for us to be saying should to our clients. And I emphasize that because I think that that's a really easy way for us to remember where that line can be. When we work to empower our clients, when we work to give them and provide them with informed consent for things, it really is easy to not do the unauthorized practice of law because we're really just abiding by those standards of what it means to provide holistic, trauma-informed, and empowered services to clients.
So another question that popped in is informing someone of their rights under the law or some specific law considered the unauthorized practice of law. It is not. So you as advocates and non-attorneys can provide all the information in the world, and please do, and especially around their victim rights.
I think a good example of that I often reference for people is when we see all of these, all of the Know Your Rights trainings for defendants, those are often not provided by attorneys. They're often provided by social workers and community-based organizations. The same is true for victims. We want to make sure that community-based organizations and advocates are very aware of the rights entitled to victims and that they're sharing them widely and with a good, thorough understanding of what all of that entails.
So one of the things that we often hear from the field and from community-based advocates in particular is that they might have a victim survivor who's going through the criminal justice process, and they say, you know, should I do a victim impact statement? And your answer is, it is your right to provide a victim impact statement if that's what you want to. Here's the intent of what that statement does, and here's the purpose of that, and here's what happens to that after that particular court date. And here's how you could give it. You can write it down. You can have a representative or someone read it to the court on your behalf. You can say it directly to the court, et cetera, and that's your right under the Colorado VRA. And that is not giving legal advice, because you'll hear that nowhere in what I just said did I say, you should write a victim impact statement and make sure that you include that you lost your job and the financial impact that this has had for you and the distress and all the therapy that you're going through right now, and just make sure you get that in there. So hopefully you can see the nuance between those two answers. And someone might have a lot of questions about, you know, is it okay if I say this? And a lot of times that's a question we get asked is it okay if I say something really mean about the defendant in my victim impact statement? And usually my response to that is, here's what I've seen happen in the past when people have done that. You have the right to share your experience in this victim impact statement. It is one of the few opportunities that victims have to really express themselves without having to be in the middle of giving testimony. And so we usually have a conversation about, you know, this is what I've seen, here's the impacts that it's had on other victims when they've done these things, and that you have to make a decision for yourself if you're comfortable with those potential impacts happening on your case. I can't say what they would be specifically or share with you what I think will happen, but just what I've seen and then what your rights are and what you're entitled to in that regard. Another quick example that frequently comes up is victims or survivors saying, I have a mandatory protection order as part of my criminal case. Do I need to go get a civil protection order? It is a really good one because it's nuanced, and we hear a lot that non-attorneys are saying, no, you should be fine with that one. The mandatory protection order will cover it. They're kind of the same thing.
We hear that a lot from the criminal justice system too, which is, you know, you have a mandatory protection order, don't worry about it. You know, once this case goes away in, 5 years after the person's been in jail for a little while and is on probation, then you can apply for it then.
And there are several reasons why that may or may not be true. That's going to be nuanced, and it's something that a victim survivor needs to think about to have more information about that. So on the flip side of that, we often hear like, sure, you can go get a civil protection order, which is true. That's not giving legal advice. But yeah, you should run out and do that. There are things about making sure that the victim survivor is getting correct information so they can anticipate next steps. One of the things that we often share is things that are said and that happen in a civil hearing while there's a criminal case going on is open to come into the criminal case. So in civil protection orders, often you have a victim who has to provide testimony about what happened to them. and that goes on record. And one of the issues that we have seen come up and derail a criminal case and actually holding an offender accountable is that the information that a victim survivor shares and might remember in that civil protection order case might differ from the information they maybe gave in their original police report, which is not uncommon, but I think that that's, and it can easily be explained through the lens of trauma and different scenarios and all of that. I think as community-based advocates we understand that, or system-based advocates we understand why a victim survivor might remember something right now, but or says something in court that they didn't say to law enforcement. Maybe it's for safety reasons, maybe it's for literally they didn't remember it when they were being questioned before, etc. But there are things that could happen then that could really derail the criminal prosecution. And so that's where we really do advise, I shouldn't say that, we recommend strongly that a victim survivor talk to an attorney who can think through some of those things about that intersection between the criminal and civil system, and how while they are two separate systems in and of themselves and they do serve different purposes, that we're not unintentionally guiding a victim survivor to make a choice that might not be in their best interest in the long run. So I think that's also an important thing to keep in mind.
And that is, I think, is a great example, because also on protection order forms, which we were talking about earlier, we should not be filling out forms for our clients or advising them what to fill out or not put on there. Even if someone is checking off boxes on what might have happened, that can, on a protection order, that can be brought into a criminal case as well. And if we are telling them, yeah, you want to fill this out, or you don't want to check this box for whatever reason, or giving them advice as to how to complete that, that is the unauthorized practice of law and clearly would have really significant implications. You know, a prosecutor or a defense attorney could ask, you know, you didn't put this on your protection order, so obviously you're just saying this for the criminal case. They get in more trouble, or they get in trouble at all. So we want to make sure that we're not doing that to prevent moments like that. And again, getting folks connected to individuals who have that expertise or the training as attorneys. You know, I think Emily caught herself when she was saying we advise people talk to attorneys, but that's another area. We don't ever want to tell people that they should go out and get an attorney. We want to make sure that we let them know. We've seen it that people have found it helpful to talk to an attorney about this issue before. It is an option that you could talk to an attorney.
Yes. Okay, so we're going to move on to the next slide. I think that in the last sentence of this slide says, ensure the court knows that the victim wants to be heard and is present, or that maybe someone isn't enforcing their rights, perhaps. So that actually comes up as a question of, but what does that actually look like? I'm just a community-based advocate. How do I make sure a judge knows what that the victim's rights aren't being represented, and what can I do? And this is where we kind of loop back to saying that relationships with the district attorney, they can be difficult to build. In some jurisdictions, they're really easy and they're there and seamless, and then in others, it's a bit more challenging. But as advocates, we have to step up to the plate and address some more of those tense areas sometimes. And so alerting the district attorney that the victim is in the courtroom and present, that doesn't waive your confidentiality. And if the victim says that it's okay for you to go tell the DA that they're there, go for it. Alert the clerk that the victim is present, and if you don't know who the clerk is, usually it's the person who is not the one who's taking notes out in front, but is the one who's sitting next to the judge and doing things like scheduling or helping shuffle paperwork around. And that person, you'll often see the attorneys kind of waving that person down or approaching that person. That is something that as community-based victim advocates or system-based advocates, you can do that as well, and make sure the clerk knows, like, I'm not sure the DA, I haven't seen the DA come in yet, but I did want to make sure the court knows that the victim is present, and then the clerk will make sure that information gets to the judge and that happens. You probably also want to tell the DA when they come in, and not just go around the DA. But if the DA is not there or they're not listening to you, you can let the clerk know directly. As a non-attorney, you can stand with the victim when they're making their, when they're addressing the court. Usually when they're providing testimony, you cannot sit with them up on, in the box. Yeah, in the wind, thank you, in the box. You can speak on behalf of the victim if they would prefer. So there is a pretty big nuance with this, and I'll let Ashley talk about that.
Yeah, so again, this only applies to when the individual is addressing the court, not during testimony. And what that usually looks like is if someone is feeling, maybe they hate public speaking, or they feel like they can't get through their statement because they'd start crying and they don't want to do that in front of other people. A lot of times what folks will do is they'll write out a written statement, give that to me, and I can speak on their behalf. I do not represent that I've written this. I don't represent that this person is necessarily represented by our office, just that they're who I am. And I oftentimes don't even necessarily share my role at RMVLC. This person's just asked me to speak on their behalf, and I will explain who it is I'm speaking on behalf of. My name is Ashley Ahrens. I'm speaking on behalf of the victim's mother, for example. And then I would read the statement as it's written and then step down from speaking. So I think that in terms of nuance, you just want to make sure you're not misrepresenting what is this statement coming from, who I am. You know, if the victim does want you to say where you're from, you could do that, but I usually just allow myself to read exactly what is written as just a separate person than the victim themselves.
And one of the important things that for those of you who do have privilege and confidentiality, so if you're not a system-based advocate or directly an attorney representing the victim, you do want to make sure that you have a very specific time-limited release of information to do that before you do that, because you want to make sure that your records beyond that stay sealed. So when we talk about specific, in that kind of scenario, if I were an advocate for a survivor who was asking me to read the statement ahead, we would put the date of the court date on there, and it would say for the purpose of reading my victim impact statement for the court and nothing else. And so I couldn't share additional information about, oh yeah, like to talk about the impact that this has had on the victim. That would be wildly inappropriate. And also likely the unauthorized practice of law and breaking confidentiality and all sorts of things that are outside the scope of doing that. But you are allowed to speak on behalf of the victim. Or if the court says, what is the victim's position on this? And the victim looks at you and panics and doesn't want to actually tell the court, they can tell you and give you permission to actually tell the court. Again, I say all this, but you're going to also want to check in with your policies and procedures at your organization if you're a community-based advocate about what the boundaries or maybe your managers have around that. But generally, if you need help with that and thinking through how that looks without representing yourself as their legal representative in the court of law, feel free to contact us. Both Ashley and I have ample experience doing things like this on behalf of victims from not only our roles here as the Rocky Mountain Victim Law Center, but also as a community-based advocate, and what things you need to think through to protect things like privacy, confidentiality, your records, etc.
And then last, there's a couple more in this chart. So certainly you can help a victim prepare a written statement or a letter ahead of time. And then I think also that sort of speaks to letting them know what that would be used for and giving the informed consent component of, if this is a victim impact statement being given at sentencing and you're also giving a written copy, that would follow that person beyond sentencing to any parole or probation hearings that they may have. And arranging alternative means if the victim is unable to be present at the hearing. So advocating on behalf of the victim to be able to join into the conversation, again, let's use sentencing as an example, via telephone. I think that's the most common one that we see.
Yeah.
So I think those are really important. Before we jump into what to do when that doesn't work, we have a couple questions. Let me see if I can pull them up. So yeah, looks like the first one we got was, should we put as much information as possible on an ex parte? So you're asking us for legal advice, so I'm going to echo back to you sort of what it is that we can share. We have seen it to be both helpful and not helpful for people to include lots of information on an ex parte component of the PO form. I would suggest potentially talking through with your organization what it is that they typically see, what it is that they typically use as examples for that, and then our office, the program that I'm a part of, the VRA program, we don't do protection orders, so I can't even give you experience from my personal cases that I've worked on. So I would encourage you to reach out to attorneys that work on this regularly to get some input from them and some insight as to, what could I share with someone without practicing their authorized practice of law about the commonalities we see in providing lots of or less information.
Another great resource might be the advocates over at Project Safeguard, which is a program located in the metro area, but they do this as their regular practice as well. And so even just, tapping them and saying, hey, what is your practice around this, and how do you approach this, and what is your organization's thoughts about doing it? That would be really important, and their advocates are supervised by an attorney, so you might get some really good practice recommendations from that particular organization.
The next question is, I get not filling out the protection order application for a client, but what about a victim's comp app? I think you addressed this. We didn't address it, so great question. We did talk about victim comp applications at the beginning as something that our advocates can help with. It's really along the same lines as protection orders, so we want to be really careful that we're, again, not filling out the victim comp application for them, but working with them to understand, here's what happens when you fill this out, or here's what we've seen happen in the past with these. Here are the things you can include. Here's what we typically see covered by the victim comp board in our jurisdiction. But then also wanting to realize that, the way that someone fills out a victim's comp application can have legal ramifications. There have been cases where the district attorney will not able to get the exact things that are covered by victim's comp. Like, they may not know that this person is receiving 20 therapy sessions. They can get a total bill amount. So we want to make sure that, we're not providing the legal advice there, because it can have implications on our case.
Not particularly.
Yeah.
Chat back in if you have more questions specifically about the victim's comp application, or an example that we can address, maybe how we would recommend dealing with it.
But it's much the same as any other sort of legal form, because it is connected to their legal case.
And I also think it's important to highlight that each jurisdiction has its own victims comp board and victims comp process, and so it's sometimes easier, I think, as a statewide organization for the Rocky Mountain Victim Law Center to say, generally speaking, here's how we see it go. But you all who are experts practicing directly in your communities are going to know a little bit more, have more information about what other victims have put in and what's helpful, what's not helpful, etc. As long as you're not saying you should include this in your victim's comp application, or I would highly recommend that you say, yeah. So that's kind of where we also see that statement of, I can't give you legal advice, but we see that used in great ways by victim advocates. We see it used in that kind of wink, wink way, like, I'm not an attorney, I can't give you legal advice, but you should maybe put in X, Y, or Z into whatever form you're filling out. And that is the unauthorized practice of law, even though you've disclosed you're not an attorney and that you can't give legal advice. So just keep that in mind, whereas I can't give you legal advice, but here's all the information around that. That's what good practice and a good way to use that statement. And then there's a suggestion that when standing with a person at court, most of the times the courts will ask you who you are and some will not. I will introduce myself as a non-attorney advocate just to be clear. Do you do this as well? Only if we're asked.
Yeah. If I'm asked, I'll explain to people that I'm the client services director, I'm not an attorney, and this is my name, and here's the statement. But I usually won't give that information unless I'm specifically asked.
If let's say Ashley is a survivor and she's about to give her victim impact statement and I'm standing next to her as emotional support, sometimes the DA will even say, and this is Emily, her advocate from the community, and just introduce me. Or occasionally, the court will say, and who's this other person, wondering if I'm in line to make another victim impact statement, etc. And so if I'm not asked who I am, that is really the victim or survivor's moment to have the stage, and I'm really there as a wing person to be the helping hand, to help them locate the tissues if they need it, to get them a cup of water if they need it in the middle, and I'm standing right there next to them, and working with the system-based advocate, if there is one, to make sure that the victim survivor is comfortable. Oftentimes, victims will ask, can you just stand to my side so that I don't have the defendant or the defense attorney right in my side view? So sometimes I literally stand there as like a block or to act as a wall. But generally is, do we automatically introduce ourselves? Not necessarily if we're just there as a support person. If we are reading the victim impact statement, more often than not, yes, we do identify who we are. That's a great question. There's a ton more questions moving in. Keep them coming. Are there sample organizational policies that you can share to help our advocates avoid the unauthorized practice of law? I don't think we have anything written beyond this PowerPoint and how you have to think about that. So usually it's a thing we provide through training and then recommend that organizations have supervisors of advocates who really understand the nuances of these things and can provide some really good support and guidance when you know there might be walking that fine line and you're not necessarily sure what side you're standing on of it. I think that supervisors need to be really sure of what does constitute the unauthorized practice of law and what doesn't. And that's something that I invested when I was a supervisor at a community-based program, invested a ton of my time making sure that I was calling the Rocky Mountain Victim Law Center or other places to say, you know, am I doing this right? You know, what kind of, what things should I be aware of? What things should I be thinking through as we're helping this particular victim and they ask us these particular questions? So unfortunately, we don't have anything particular. However, if your organization does write some policies or some procedures that you would like us to look at, we'd be happy to provide that kind of technical assistance and support to your organization as you look at implementing different policies and procedures specifically related to this.
So the next one, so if a domestic violence victim flees the home with the children, can we refer them to the DA's office to determine what to do in regards to a good cause violation?
Great question. So we might need more information about that. And what has the victim survivor been caught with that? That might be a hypothetical I would ask the DA rather than asking and saying, so hey, this case that you're prosecuting where so-and-so is a victim, they fled, because you wouldn't want to be sharing information that maybe they don't already know. So there are times where in my role as a community-based advocate, I would call the DA and say, hypothetically speaking, if you were prosecuting, let's say, a domestic violence case and the victim survivor fled with the kids, you know, there's also civil legal implications with that, especially if there are custody orders in place, where that victim survivor could be in a lot of trouble and you don't want to ask the wrong question or somehow show your hand or show the survivor's hand without their consent and knowledge and support around that. So I would say the answer, generally speaking, is no, I would not automatically refer something to the DA pretty much ever, and make sure that that victim survivor has an advocate who can really help them think through that, both on the criminal side and the civil legal side, because there's likely to be things that come up on both ends, and you don't want to inadvertently get that victim survivor in trouble. So let us know if that answers your question or if there's more particulars you want us to think about with that.
Okay. For an individual that doesn't read or write well, is it recommended that Project Safeguard assist with filling out the form for a protection order?
So Project Safeguard only works with domestic violence survivors, and they're also going to have to make that decision for themselves. What I would say that is that if you're not an attorney and protection orders is not the primary thing that you're doing in your role, and if you don't have a policy or procedure on this, I would say that you shouldn't do that on behalf of someone. That does constitute as the unauthorized practice of law. Now, as Project Safeguard, as with Rocky Mountain Victim Law Center, we're a little bit different in that if I'm doing something like that under the supervision of an attorney and the direction of an attorney and they're checking my work, I might be able to do that. And so this is where it might be wise, and it's probably wise, to get an attorney to give you some direct advice in that particular situation.
And certainly to reach out if you're not from Project Safeguard. If you're from Project Safeguard and asking this question, then this is not going to be a helpful answer. But you might want to just reach out directly to Project Safeguard and find out what their policies and procedures are to see sort of what they've established as an organization they're comfortable with in terms of an attorney assisting or supervising, and then that person assisting in that way.
We also got asked, can you all have a version of this PowerPoint? Absolutely. The CICASA folks will send that out to you after we're done today. So the question was, how do we stand up for a victim in court without the judge or lawyers getting upset? There's no guarantee that people aren't going to get upset with you. I think as an advocate, part of our role is to be able to stand and hold space during uncomfortable moments. I do think that sometimes there is a sense that victims, advocates, and even victims themselves at times don't necessarily or shouldn't speak up in court, that there isn't space for that. But I think that part of what our role is again, as we mentioned before, is to build the collaboration in advance. Find out what a DA might appreciate in terms of a heads up of like, oh, I am going to speak, or this victim is going to speak, or I'm going to speak on behalf of this victim. I think the less surprises that we can provide to people in advance can be helpful. And it also helps us engage, is this person going to be resistant to us talking or advocating in this way? I think it's very rarely, if the victim's not present, it's hard to justify us speaking without them. I think, that's an area when Emily was mentioning earlier, this idea that, what is the victim's position? I've been asked that in court before, and it is not appropriate for me if I have not had that conversation in advance of the victim and gotten a release from them to share that in any way. So that sort of advocacy is inappropriate and is absolutely the unauthorized practice of law. However, there have been times when I've stood up and shared information that a victim has relayed to me that's been frustrating for the court, especially if a victim stands in a different, or has a different opinion or a different stance than the DA's office. But at the same time, again, I think that it's a matter of learning to sort of handle and sit with that uncomfortability and move through it, knowing that our victims need us to do that. And it's not a simple skill to build. It takes time. And I know for me, the first few times I had to do that, my heart was racing, and I sweat even more than usual. So we definitely want to make sure that we're getting extra supervision and support around those moments as well. Yeah, definitely. And I know in my experience, sometimes my voice shakes. I get really maybe dissociated a little bit, where I'm like, what did I just say, and was it appropriate? Which is all pretty normal. I think that, as the advocacy field has grown, and as we have emphasized needing to collaborate and participate and work with our partners, some of what has been lost in community-based advocacy is this idea or notion that that it needs to be peaceful all the time, and we need to get along all the time, and we need to be in agreement all the time. And while it's important to have consensus, and definitely much easier to have consensus around certain issues, we can still maintain relationships without being confrontational or adversarial or picking a fight or writing this DA off as they don't care about victims, or this system-based advocate, they're just not being very helpful. Whatever that is, I think there's different ways to do it, and that's where we also talk about advanced advocacy, is that, I can go to a DA and say, I get that you're not going to do this, and, it's helpful for me to understand why, and yet it is the victim's right to have this happen, and this is what they want, and it is my role to make sure that that's shared. And so, and not being apologetic for it. So I would say, never say, I'm sorry that I'm going to have to say something other than you, because you shouldn't be sorry for that. It is your job as an advocate to get out there and actually advocate on behalf of victims. But to say, it's unfortunate that maybe we stand in different positions on this, and I really appreciate how we've had a great working relationship and look forward to that, and it is my role to share something that differs with your opinion in this particular situation. And every time that I've had that kind of conversation with whether it be a DA or a law enforcement officer or someone else, I think that garners a lot more respect, that they understand that I'm standing my ground and advocating fiercely on behalf of victims, and that's a respectable thing to do. Now, if I come in there saying, you don't know what you're talking about, I don't understand why you don't care about this victim, and you know what, if you're not going to share it, I'm going to. That's a very different tone, even though I just said the exact same thing that I said in the first iteration of that scenario. So I do think it's important. It can be scary, it can be hard, but when we really get into advanced advocacy and effective advocacy, it's okay to be have opposite stances on things. And so that's just something that we usually share. Okay, we're reading more questions.
Yeah.
These are all great questions.
How do we go about protecting or keeping a respondent from intimidating our victim, and can we ask the judge to address this issue? So a lot of times it's sort of an opportunity if there is, I guess, it's challenging, right? Like sometimes we want to make sure that a DA knows that this is happening, particularly if the facts of the case are such that this is an ongoing pattern or there's been some sort of reason to anticipate that this is going to be something that continues to happen or could impact the case in some way. And so a lot of times we found it beneficial that victims are connected back to the DA's office to share with them that this is happening, this intimidation. Additionally, because oftentimes the courthouse can be a really intimidating experience anyway. They know that the defendant is there. They know that there's the very real potential that they could run into that person in the hallway. You know, victims are entitled to a safe and safe waiting room leading up to court if practicable. So
Under the VRA.
Under the VRA. So if that isn't practicable, you know, where is that person meeting, and just being able to talk through those pieces. I think, you know, sometimes the DAs have a better understanding of that, or the system-based advocate, for that matter, have a better understanding of how to assist with that because they're in that courthouse all the time, every day, and have likely seen this issue come up before. So that could be kind of going back to what we talked about before. If you're concerned about the relationship that a victim has with the DA's office for any reason, that could be a great time to reach out and build that collaboration through hypotheticals with someone, maybe not necessarily that person's victim advocate or DA, but someone from that office to be like, how do you all usually handle safety concerns, or what do we usually see happen when you are concerned about the intimidation that's occurring for this victim, or for a victim, I should say. So usually that is the route if there is some concern about how the DA's office would handle that. But it's pretty uncommon that the DA's office shouldn't know or wouldn't want to know that this is happening. You know, it's not as, usually there aren't as many concerns as like, oh, this person's been in therapy recently and has started doing, you know, this, that, and the other, and then divulging that information to the DA's office and not having to be disclosed. The fact that there are safety issues usually doesn't hold the same sort of concerns about privacy for a victim. I think that's a good question, isn't it?
Yeah, and I definitely think that's where, in my experience, having a really strong relationship with the system-based advocate to help work out some of those safety concerns has been super beneficial and easy, and having some of those conversations about what my role is and how that's similar in some ways and different in some ways from the system-based advocate, and how we can work together to make sure that that survivor's experience, that they do feel supported and safe, and how we as professionals and both as advocates with similar yet very different roles and different levels of confidentiality can really support this person through the process.
So it looks like there is some more information about the previous question. So it says, if a mother leaves an abuser because of DV and takes the children prior to reporting to law enforcement and she is taking them to protect them from any further exposure to domestic violence, some people will report a good cause violation to protect themselves in case the abuser reports the children as kidnapped. Will this help the victim protect themselves legally while they wait to file custody or restraining orders? So this is an answer that we can't give you, because telling you whether or not this is a good idea would be the unauthorized practice of law. So what we might suggest is talking to someone who has an expertise in the area of child custody and domestic relations, but with a good understanding of domestic violence. And there are a number of people within the community who do have that. You know, people who have been prior prosecutors, who have done training around domestic violence. So that would be usually what we suggest to people, is that, you know, having an attorney who understands the custody part in particular, because we do see this really frequently in DV cases. But wanting to make sure that, you know, we can't tell you whether it's a good idea for a victim to do that, because it's the first practice of law.
Yeah, So again, if you need access to some of those resources or want, an idea of who you could talk to, a lot of times attorneys will do a free initial consultation. So that doesn't mean they're taking on a case, but they might actually field this question and give a recommendation about what they think you should do. And so that is important to do just as an organization. I know that frequently when I've worked at community-based organizations, I've had kind of a go-to attorney that I had established a relationship with that I could say, what do you think about this? Or, what direction would you point me? Sometimes it would be, you know what, you need to call a different attorney on this, call this person, they're a friend of mine, I'll give them a heads up that you're calling, who specializes in whatever the question is that I was asking, and then could provide a little bit of guidance about how I could navigate that or what the appropriate resource for the victim survivor was. So oftentimes, as a community-based advocate, I would wonder, what kind of attorney do I need for this, or what kind of attorney does this victim need for this particular issue, or does the victim survivor even need an attorney, and what does that look like? And so, again, building those relationships. Again, you can always call on these very specific questions. It's great to call our office. Now, if a survivor is calling your organization and saying, I'm thinking about leaving, would you recommend that I call law enforcement or the DA and have report a good cause violation? Likely your answer should be, I can't offer you advice around that, and it could have implications both on the criminal legal side and the civil legal side. You're likely going to want to consult with an attorney who could provide you a better answer specific to your situation and what's going on. And I think that is the appropriate answer if you yourself are not an attorney. Is to refer that person back to maybe if they have a divorce attorney or an attorney they've been working with for custody. If they don't, then helping them find the Colorado Legal Services if they're accessible, or maybe a legal clinic. That might be, there's virtual clinics that now happen all over the state. So if you need access to those kind of resources and where to help point that victim survivor, feel free to call our office and we can give some information about who they could ask that particular question.
One thing that I would add that was a big shift for me moving from my community-based advocacy sort of role to this particular organization is that the law world moves slower. So part of why we talk a lot about collaboration on the front end of things is that if you call a law office, it may take 2 business days to get a call back. And if the person has already fled and is waiting to figure out whether or not they should call, it just delays things. So wanting to build those relationships in advance so that you can or do have a direct contact potentially to get a call back more quickly, particularly for low-cost, sliding scale legal clinics, just like any other nonprofit working with victims or working with marginalized communities. There's usually way more people in need of services than there is hours in the day. And so wanting to make sure that you are able to have a conversation with victims in advance of, if something comes up where we need legal advice, if you start to see that this might be this person is starting to talk about fleeing, starting to talk about the legal implications of doing so, wanting to have a conversation with them about if there is a way that we can have, a day or two to plan for some of this in advance of you doing something, then that's great. Otherwise, it really benefits you to have a direct contact or a few contacts at a law office or a few different law offices to cover those bases and make sure you can get answers quickly, because that is a big, big difference. Law offices usually don't do crisis work in the same way that crisis organizations do. And so the turnaround on getting answers can be much longer than a victim needs it to be. And that is a challenging part, I think, for folks to understand when they're coming from the crisis-based victim services to something like our office or other legal clinics. Excellent. So we have a little bit more time. I know we have some more slides.
We only have,
no, okay.
That is it. So one of the things we were going to ask you all to do is, if you could go to the next slide, what are some examples you run into your work when you're unsure of what to do or what to say when it comes to a legal proceeding or process related to, that was us, to the victim or survivor. So we're going to open up our question box again and give you all a little bit of time to ask, again, some more particular questions about what would you do in X, Y, or Z situation. while you're typing, one of the things that came to mind while we were talking through things is that we often, as community-based advocates, we often talk about how there is a difference between the civil system and the criminal system, and what is very frustrating for survivors often is the fact that those two systems don't talk, but when they do, it can be pretty explosive and derailing and surprising, and as advocates, we want to make sure that there are, to the extent possible, that we can be giving information about avoiding any sort of surprises. So that's not always possible. There's always things that happen in legal proceedings that are last minute or that you couldn't anticipate. You certainly can't anticipate for everything that would happen. But to the extent possible, it's important to be thinking ahead of what this could look like, what could happen, and preparing the survivor for that. One of the things where we talk about these worlds don't, while we have different proceedings, is around, I like to talk about the Title IX proceedings, which often come up for victim survivors. So often victim survivors may decide to report into to law enforcement, let's say a sex assault on campus. They report it to law enforcement, that's going through a criminal investigation, and they also choose to go through whatever the Title IX process is with their campus. So making a report to campus, it's usually under the Student Code of Conduct. And there's another investigation that's happening in that. Often what we see is that the respondent in those school cases, so the offender, likely has counsel and has an attorney there, and often victim survivors don't have counsel during that. But there's all sorts of information that gets shared during those proceedings that could also come into the criminal justice process. And helping, as advocates, I think it's important to help a victim survivor understand when they're signing things in this totally separate process, and we talk about it as a separate process because it is a separate process, but similar to protection orders or divorce and custody hearings that are maybe running in parallel to a criminal case, that these things could come in. The other thing is that we have heard community-based advocates saying, I totally lost my train of thought. Things coming in, we had a great question come in. So one of the other things we see community-based organizations saying is, oh, just wait and hold on to file whatever that civil thing is that the victim wants to file. But what's really important is to note that's the unauthorized practice of law, because you're directing them not to do something legally. But also it's important to know that for certain legal issues there is a statute of limitations, and so you might not want to let the criminal case run because it might be out of time to do whatever the victim survivor was hoping to file on the civil side. And so that again is a very clear example of, I would say, things like, you know, you might be interested in filing something civilly, and that might be an option to you. You're going to want to talk to an attorney about the timing of that, a civil attorney who would actually maybe file that case, not the district attorney. But making sure that you're not saying, oh, that can wait, don't worry about it right now, because that would constitute as the unauthorized practice of law because you're guiding them not to do something right now. We have questions rolling in and about 7 minutes left, so we're going to read some of these.
So the first one is asking clients to sign a general release of information form in order to vaguely explain their situation to legal representatives to get their advice on who to contact or resources in the community that I can relay back to the survivor so that they can reach out if they want to. So I'm assuming what you're asking is it appropriate to get a client to sign a general release of information, and the answer is yes. The more information that you can share with any sort of legal clinic, or if you were calling our office, for example, is going to help us know whether or not we're going to be a good resource for them. You know, the more you can share with us also decreases the amount of information that person will have to share if they do call us for services during an intake. So that's, I think, if I hope of answering your question right.
I'm going to add a big caveat and however to that is you might not need to. So if I'm working with a victim survivor who is like asking questions about what are, let's say they've received a subpoena for their mental health records and they don't know what to do with that, and you're asking them, you know, can you vaguely explain their situation? If you're vaguely explaining their situation to a legal representative, whether it be Rocky Mountain Victim Law Center, and you call and say, hi, my name is Sally. I'm working with a sex assault survivor who has a criminal case, and they have received a subpoena for X, Y, or Z issue. What might I do, or what in this situation, what can I tell the survivor? You don't need a release, and I would strongly recommend not getting a release, because you don't want to just be running out getting releases of information, because that can open the door for things that you don't want to do. And especially when talking to a district attorney or someone else who doesn't have confidentiality, you don't want to get a release. So you can say, hypothetically speaking, if I were working with a victim and this kind of scenario popped up, what would you recommend that I kind of help them do? As long as you're not sharing any specific details about their case, so you wouldn't want to say, I have a survivor who was sexually assaulted at Joe's bar last week, and blah, blah, blah. That could connect someone back to knowing. Or I have a survivor who was sexually assaulted in this very high-profile case in Grand Junction. Likely we would be able to figure out who that victim is. So you're going to want to, again, when we're thinking about advanced advocacy, you have to think a little bit critically about how you're sharing that information. Now, if someone from Advocacy Center in Grand Junction calls and says, I'm working with a sex assault survivor and we have concerns about media, that's not going to give me enough information to be able to identify whose case that is by just like Googling sex assault cases. I might have some good guesses, but I'm not going to know, so that's not breaking confidentiality. But generally speaking, one, we don't normally advise that you ever sign general releases of information, that they do need to be very specific and narrowly tailored to a particular topic, to what the victim survivor does and does not want, and you as an advocate should think through, is it necessary to share the exact details of this victim's case before sharing that? So the answer is kind of yes or no, and if you're curious about whether or not to have a general release of information signed, that would be a great thing as an advocate to pick up the phone and say, hey Emily, I generally have this going on, I need to reach out and talk to this person. Do you think that this would constitute something that needs to have a release of information? I can talk through with you about what you are and are not thinking about sharing and help you think about whether or not it's necessary to have a ROI.
So the next question, I have a situation where the father has an intellectual and developmental disability. He is technically legally married to 2 women. The one he considers his ex took his sons out of state without his permission. He wants to divorce this person and get at least joint custody of his son. Thoughts? So this isn't really our area of expertise by any means. It's not at all. So I don't know why I said it like that. So I think part of what we would usually recommend if this call came in on a intake would be to get you connected to someone who has a better understanding of this type of law. So it would be domestic relations and potentially maybe even getting you connected to like Disability Law Colorado, wanting to connect you to someone who has both the domestic relations side but then also the side working with folks who have intellectual and developmental disabilities.
Definitely. And again, those are organizations that you as service providers can reach out to directly, or you could ask the victim survivor to call some of these places.
And it looks like that's what you were asking for in the second question, just without the providing an unauthorized practice of law, where do you suggest you contact? So that would be my suggestion.
Yep. Let's see. So another question we had come in. See, I don't know if I can answer a victim's questions around statute of limitations on a certain crime. It seems like I have to interpret the statute and don't feel confident in my ability to do that. Exactly. So you want to know that there are statutes of limitations, but you wouldn't want to tell someone to apply for something or to go ahead and file a civil or criminal complaint about a victimization that they've experienced based on whatever you think the statute of limitations are, because they're very, one, that is the unauthorized practice of law. But generally, what is important to say is, you know, there are some probably considerations you could think through about statute of limitations. They're going to be different depending on your particular scenario and situation and the victimization that you've experienced, and you're going to want to talk to an attorney about that to kind of figure out what's the best option for you. So, but the difference between that answer is saying there is statute of limitations. In your case, you've got 90 days to file this, and so you're going to want to get on that. That is absolutely the unauthorized practice of law. So, but again, giving that information that there might be a statute of limitations applied to this certain thing that you're looking and seeking for, and it's important for you to know that it might be time limited. So, to check on things to make sure that ship doesn't sail without you knowing it.
Next question, I work with someone who has a restraining order who has called police on violations of the order, is giving information on what constitutes a violation, unauthorized practice of law. She asks for clarification all the time. She's afraid to call the police for clarification.
Okay. Sorry, I was just checking the watch and didn't pay attention.
So I don't believe that giving the person, for example, if you were to say, here's the statute, here's what, you know, a violation of a protection order is, that is not the unauthorized practice of law. It's how it particularly applies to that person's case and then interpreting that. So, for example, if you were to say, well, on your case, this is what this violation is going to look like. That you can't do. But you could give someone, hey, here's the statute. And in some cases, particularly with folks with trauma, it may be helpful to provide that information to them in a couple different ways. So if you're finding that you're constantly providing that information over the phone and over the phone again, it may be helpful to let that person have the statute. Give them an opportunity to have something written where it's a little bit easier to refer back to, and then you all could talk through that. Like, oh, do you remember the time that I gave you this? You know, here are the ways that we see the violation of protection order defined in the statute. Additionally, I know we referred to this earlier, it may be valuable to connect them with the link website because they have that in a very easily readable 8th to 10th grade reading level to define all of those different types of things.
And I am noting that we are over our time, and so we apologize for that. But what we'll do is we'll close now. I popped up the last screen so that you all can see both Ashley's email address and my own, where you're welcome to continue to email us questions and comments. Of course, you can always contact CASA for some of this information and resources for you all, and we've really appreciated being here with you all and sharing some of this information, and hope to be in contact with you all in the future as you continue to provide great services to survivors across the state, and hopefully we can be a resource to you all. So thank you for the work you do. Thanks.
Well, thank you so much to Emily and Ashley. This has been an amazing 3 webinars that you have provided for us, and we hope to continue doing some more as we get the request for it. I will also like to remind everybody to please fill out the survey at the end of this webinar, and that we will send you the PowerPoint with all the information that we get after Emily and Ashley send us the PowerPoints. So definitely, yeah. So we also would like to invite you to our next webinar, which will be March 16, and the title of that one is Pornography and its Connections to Rape Culture. So we hope to see you all to the next webinar on March 16. Again, thank you so much to our presenters. You are fantastic, and you have provided so much information. Thank you all. Have a wonderful day. You were saying bye.